A very warm welcome to all our participants for this particular webinar. It gives me immense pleasure to welcome you all to this fifth webinar of the webinar series on mediation. This webinar is on the topic of an insight into mediation as a form of ADR, and the speaker for the event is Dr. Gitanjali Prabhu Shetty ji. And the moderator would be our esteemed council member CS Ashish Karodia ji. Over to Sri Ashish Karodia ji. Sir, please.
Thank you. Thank you. Good afternoon, everyone. I welcome all the esteemed members to this learning session. As we are aware, the Institute is committed to impart continuous knowledge and information regarding various opportunities and roles for a company secretary. One such avenue is mediation, and it won't be one overstatement to say that it is one of the most sought after profile and a reasonable one too. Being a mediator, it is very difficult task to perform, and it is important to understand the complete ins and outs of the job before forming any conclusion. Friends, a mediator has to understand all the aspects of the case to make a suitable decision for both parties. Usually, this decision is a settlement, and both parties have to compromise a little rather than it being a complete win for one involved party. Friends, the topic for today's session is an insight into mediation as a form of ADR. Today we have with us Dr. Gitanjali Prabhu Shetty. I welcome her. And friends, she is a PhD in law and practical counsel in the Mumbai High Court and experienced arbitrator and internationally certified trained mediator. She is a practicing counsel in the High Court for the last more than 25 years. She is presently a visiting faculty with the Maharashtra National Law University for MA in mediation for last 3 years. She is a versatile faculty with the Department of Law, Mumbai University for over a decade to students pursuing Master in Law, teaching Constitutional Law and Environmental Law. She has undertaken several training programs in mediation, including in the Indian Institute of Corporate Affairs, IICA, MP, MCPC training by the Honorable Supreme Court of India in 2024. She is impaneled as a mediator, Mediation Center, Mumbai High Court. She is on the executive committee of the Mediation Committee of the Indian Merchant Chambers. She is a member and on panel of the Association of Mediation Practitioner MP Mumbai. She is the vice president of the Western region of Mediators India. With this, I welcome her, and I am thankful to her for accepting our invitation. And I request her to please commence the session and enlighten us. Welcome, ma'am.
Thank you so much, sir, for having me for this lecture. And thank you for those kind words and narrating all my achievements so far. And I hope to add this feather in my cap today with this lecture to your wonderful audience. And I congratulate your audience for taking up this course of company secretary. They are the future of tomorrow. So without much ado, let me ignite some attraction towards mediation. With these words, let me start the lecture for today. So I have made a small PPT, but before I begin, I have to tell you all that I will most happily welcome all questions on mediation at the end of our 60 to 70 minutes of lecture. Usually I prefer a interactive lecture, but it's fine because mediation being the topic that it is too vast to encompass within a period of 60 minutes. But we need to have a little insight into why mediation. So let us start my PPT. Just give me a moment. Okay, is it visible? All right, wonderful. Okay, so this is our title for today, an insight into mediation. Now, most important, we all know one thing, that being the professionals that you are, and most of you must have gone through a bit of law, having law as business law, etc. So you must be aware as common citizens of India that the moment you have a dispute, a conflict, which is tending to a legal right, your immediate conciliation would be to choose the adversarial form of resolution, and that is approach the court of law. To approach the court of law, you will first check out on the lawyers who will help you to reach the court of law. But over a period of time, it has so happened that for hundreds of reasons, which we all are aware and unaware, the burden of resolution of disputes in courts is multiplying. We all know that today, if a suit is filed, if a writ is filed, it takes more than 10, 12 years for the parties to see the resolution to their dispute. You notice a worn down building and you immediately comment that looks like this property seems to be in a dispute. And then 10 years later, also, you see the same weathered building not having reached any resolution. Therefore, the Law Commission of India felt that we should have some other appropriate mode of resolution other than the normal going to court or legal way out. And therefore, it was felt at that time, the Legal Commission took up this task to find out what would be an appropriate remedy to this. Alternative is a word which the Law Commission doesn't seem to much like, but then it is the most simple and easy to understand to the common person. And unless a form of resolution reaches the common man, it is useless to use words which, somebody will have to sit and explain to them. Therefore, we go with the flow and say alternative dispute resolution. Now, what are the 4 different alternatives to going to court? We all know arbitration has taken up a big portion of the burden. We had conciliation. Conciliation initially started mandatorily through the Industrial Disputes Act. We have judicial settlement, and then we have mediation. Of course, if you look at Section 89 of the CPC, it talks about lok adalat, etc., etc. But for today, we concentrate on these 4 alternative modes, which are basically what is going to reign in future. The second slide will give you a little bit of a insight into arbitration, which I'm sure you are all much aware of. Arbitration is a form of dispute resolution, and we all know it is governed by the Arbitration and Conciliation Act. And there are 3 modes in which an arbitrator can be appointed. Either the parties can appoint themselves by consenting to an arbitrator, or under Section 11, you will have a court appointing an arbitrator, or then an external party like an institution. So if you have a panel like the Indian Merchant Chamber, and parties come to it, automatically in their arbitration clause, they mention that an arbitrator from the Indian Merchant Chamber or an arbitrator from any other institution will automatically be the arbitrator. So therefore, if you look at arbitration, yes, it is something cut out from the court. The advantages of arbitration is that you may not have to wait for 10 years. But again, if you look at the disadvantages of arbitration is you need to file your pleadings. The other side will file their pleadings. Again, human elements get involved. It is quite expensive. Not the common man will be able to take the advantage of arbitration. We'll see a little more of the comparison a little bit later on. Let's see what is conciliation. Conciliation is also a type of resolution. In this, what happens basically is you have parties appoint a conciliator either under a statute like the Industrial Disputes Act, where time is fixed, parties appear before the conciliator. Conciliator listens to both of them. Then he tells them and advises them that, look, this is the strong point. This is your weak point. If you go to court, you'll have to wait for so and so time. Limitation will apply. If it is a suit matter, then, the other aspects of making a party where you can file a suit, a territorial jurisdiction, etc., etc., all will apply. But in conciliation, you can happily reach a settlement. And that is a form of conciliation where the conciliator helps parties to understand what their basic strengths and weaknesses are. He helps them to reach midway. He answers all their queries, what doubts they will have about the matter at hand, what would be the future of the matter, if is the matter binding, how could they execute the award if reached in conciliation, etc. Then we have something called as a judicial settlement, which we all are aware. What happens is when there is a matter pending in court, now matter goes on and on and on, and there comes a time when parties just get fed up. Either family intervenes, lawyers intervene, anyone, third party intervenes, or they themselves see some wisdom. They come together and they have a dialogue, they negotiate, and they reach a settlement. They put all the terms of the settlement in the form of a minutes of order. That minutes of the order is reached out to the court, and the court passes an order in terms of their minutes of the order. We also call it as consent term. And finally, then therefore, what is mediation? So mediation, and why has mediation gained so much popularity over other forms of resolution? And today we also have the government was pressurized and felt the need to take into account everybody's viewpoints and pass the Mediation Act of 2023. Though the act was passed in 2023, we all know that the work behind the act must have taken more than 4 to 5 years so that they could come out with something which is strong, which takes its lesson from all over the place and would be an act which will further the cause of mediation in India. So most importantly, mediation is a voluntary process compared to arbitration, or when you have a matter in court or you have a conciliation. The once you submit yourself to an arbitration, conciliation, or you submit yourself to litigation, you know that you have to answer the summons and you have to be there. Not only you have to answer and you have to be there, you have to continue till you reach a resolution. In mediation, the moment the courts realize that there is a particular matter which can be settled between the parties, the court can refer such a matter to mediation. So coming to a mediator is mandated because of the AFCON's judgment, which says that the courts have to push for alternative dispute resolution methods where courts find, because of the overburdening in the court. Therefore, courts felt that whenever the court feels that a matter is suitable for mediation, arbitration, conciliation, the court can refer such a matter for that type of resolution. But in mediation, the advantage is simply this, that being voluntary, your attendance for mediation is compulsory. But after that, if you think that, I have, understood this and nothing is working for me, you have to just inform the mediator and say, ma'am, I really don't see anything, coming out of it. I would prefer to go back to court, or I would prefer not to come back to mediation because it doesn't help me. So this is one process which is completely voluntary, though it is a binding process, where you have an impartial, neutral, called as a mediator, who will facilitate the dispute between the parties. It is a party-centric process, meaning the parties sitting before a mediator, they are the ones who will bring in the dispute that is pending between them. They will decide whether we want to settle all the disputes, a part of the disputes, or none at all. They will decide what are the options that we will see for ourselves, which will work for us, and we will write it out in the form of a mediated settlement agreement, or we will go back to court from where the matter was referred to be called as a referral court. It is definitely but a structured process. Under the Act, if you look at mediation, what does it say? Section 2H defines mediation to include a process, whether referred to by expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person referred to as the mediator, who does not have the authority to impose a settlement upon the parties. Now, if you look at this, so what are therefore the requirements of the mediation process? It is a completely voluntary process. Second, it has to have a neutral. There should be parties in conflict or in dispute, and the parties should be willing to negotiate to reach a settlement. Such a settlement cannot be foisted on them by the mediator. It should be a settlement which is self-imposed upon themselves to the extent that they want. Even the scope of mediation is decided by the parties. Scope meaning the number of conflicts between them may be 20. They might just decide to solve all 20. They might decide to solve just 10. It is completely left to them. Now, here is a comparison between the judicial process, the arbitration, and mediation. Now, like I said, judicial process and arbitration both are adjudicatory process, in the sense both are law abiding or law pending. Both the processes depend on the law for the outcome of the outcome. Now, what does that mean? In judicial process, a judge presides over the matter. Parties refer the matter. The opposite side files their written statement or a response. The judge is bound to decide the matter by the law. He cannot take recuse in the fact that, fairness. If it is limitation, he has to go by the law and say, I'm sorry. If it is the pecuniary jurisdiction doesn't lie with him, the assignment doesn't lie with him, he will have to say, sorry, I cannot help you. You are in the wrong forum. Please go to the correct court. So his hands are completely tied. He's bound by the process and procedure of the law. Same goes for arbitration. Once an arbitrator gets appointed, the complete process of the claimants filing the claim, the defense filing its defense or counterclaim, if any, the issues raised, the findings given, the evidence led, everything is done by the arbitrator by a book of law. What about mediation? While these two are adjudicatory processes, mediation is a negotiation process. How? We'll learn it in a few moments, in a couple of slides which are coming later. Now here, when you look at what is mentioned, party paid directly in the resolution of their dispute. Now, in judicial process and arbitration, you hand over your dispute to your lawyers. Your lawyers take it from there. Your lawyers advise you that among all the grievances, conflicts that you have mentioned to them, how they have to compress it and how they have to make it fit into a particular letter of the law. And therefore, you continue from there. You cannot do a direct participation. If there is any factual question that falls from the court, a counsel or an advocate appearing for you has to turn back and then ask you, what is the reply to that? But as far as law goes, he goes by on his own between the judge and an advocate. Parties do not get to participate either in a judicial process or in an arbitration process. However, mediation being a party-centric process, parties get to directly participate in such process. Judicial is a formal process as well as arbitration, whereas mediation is an informal process. Now, what is the meaning of being formal and informal in a process? Simple. In both judicial and in arbitration, you have to file a statement of claim. or a plaint or a writ, and the other side will have to file their statement of defense, written statement, etc., etc. Whereas in mediation, nothing of the sort. In mediation, there is no pleadings to be filed at all. No pleadings to be filed at all. And that is why definitely it is not a formal proceeding. Judicial and arbitration are adversarial. Both the processes are such that parties are pitted against each other and one wins the case and the other loses the case. And therefore, there are always chances open where the losing party carries it in appeal. Mediation, however, is a collaborative process. It's a win-win process because parties sit with each other, parties decide for themselves that how did we come to this stage of misunderstanding? How do we proceed from here? How do we make it happen that both of us shake hands and walk away from here? Is that feasible? Yes, it is feasible, and it is called the magic of mediation, and that is the skill that we need to learn. Further comparison. So this we have already done. No personal appearance of parties is required either in a judicial process. So if you have a matter filed in court, you have a lawyer appearing in court, parties are generally not required unless it is a case where there is a cross-examination matter or evidence is filed and you're in cross-examination. That is the time you're summoned. Whereas even the same goes for arbitration. Your lawyers continue with the matter and you are exempted from appearing. However, in mediation, simply because it is a process where it is the parties who decide how to go ahead with the matter, it is the parties who decide how to create options, how they are going to come about a resolution, whether they're going to accept it holistically or a portion of it, whether they're going to ultimately sign the settlement, which is called as a mediated settlement agreement, all depends on the parties, and their presence, therefore, at each and every hearing is mandatory. Of course, all the three processes, whether it is a judicial process, arbitration award, or a mediation settlement, all are binding. Otherwise, the commencement and continuity of the process is meaningless. Now, this is very, very interesting, and we need to understand this in a little bit, so that we understand how mediation can then be conducted. Now, what happens is a referral court, you could have a court annex mediation when your matter is already pending in court. And the court decides that, this is a matter good enough for mediation, both the counsels agree, parties agree, or even if they disagree, the court foists this on them that, yes, go and try mediation and come back. That is called as a court annex mediation. In a court annex mediation, what happens is either the court appoints the mediator or the court then refers the matter simply to the main mediation center and the center appoints the mediator. Or in third cases, sometimes the parties themselves refer a mediator by name and say, Lordship, if we are being referred to mediation, kindly appoint so-and-so as a mediator because we have seen how the person functions. We would like to go for mediation. And the court is very happy to do so. And in this case, what happens is, if a matter is referred for mediation in a court annex matter, either the matter gets settled or the matter fails, or the parties are least interested and they abandon the proceeding. In all cases, the matter comes back to the court, that is the referral court. Now, what about pre-institution mediation? What happened some time back was the courts felt, the legislation felt that we need to mandate mediation on litigants because of their own, they are not going to make it a point to go to mediation. Let's start with commercial court matters, and therefore Section 12A of the Commercial Courts Act was amended, where every litigant who approached the court was first sent by a shortcut to mediation. So they had to fill up a form, they had to mention in brief what their matter is about and submit themselves to mediation. That 2 paragraphs of conflict, what they mentioned, was sent to the other side. The other side was made to submit to mediation. And once both the parties were submitted themselves and agreed to submit themselves to mediation, a mediator was appointed by the district legal services and the matter was sent to the mediator. In this case, what happens is, again, a couple of things could happen. If the matter succeeds, a mediated settlement agreement is automatically filed, and because of which the potential matter which could have been filed gets stopped, and parties are happy with a win-win situation because they saved themselves a lot of money, time, energy, and most importantly, they got what they wanted. Maybe they settle for a little less, little more, but at least they can now begin with their life. In this case, suppose there is a failure, then the party who had initially approached the court to file a suit then files this failure report and then continues maybe with the suit. But after hearing the other side in mediation and going through the mediation process, if the party feels that now I don't see anything coming out of this, mostly I'm satisfied, or the claim we could do an out of court settlement, even then the courts permit that you could do an out of court settlement, not necessarily before the mediator, but settle out of court, and even then that can be sorted out. What happens to now private mediation? Now, you won't believe, but suppose a lawyer does a good job by word of mouth, a chartered secretary like you people do a good job by word of mouth, immediately people come to you saying, so and so has referred me your name and you have done a fantastic job. Will you then, kindly lend your services to us? Of course, in such cases, the mediator accepts this as a private mediation and then continues as a mediator. Sometimes you also have institutions who are having a panel of mediators. And when matters get referred to them for private mediation, institution counsel parties as to what kind of a panel member would they like as a mediator who can be very, familiar with their kind of a cases, then gets selected to continue mediation. What are then the advantages of mediation because of which it has had an edge over, let's say, the legal process or arbitration? Why is the world over being so biased nowadays towards mediation? Why people are preferring it over arbitration and litigation? First, parties have control. What control? They have a control whether they want to come to mediation. They have a control to appoint a mediator of their choice. They have a control over the scope of the number of matters, number of conflict which they have amongst themselves to be referred to the mediator. They may decide that they may refer all. They may decide even after referring to just finish off 2 matters and then rest of the disputes they don't want to continue. Yes, they may want to ink it out in writing as a mediated settlement agreement. They may just don't want to ink it out. They are happy. They have understood each other's stance and they just want to say goodbye and go. They can do anything they like and it is possible. Mediation is participative. So what happens in a participative process? Simple. A party feels avenged. A party feels satiated. A party feels satisfied that this is my particular conflict and this is the conflict which I have told to the person responsible for it. I have seen his response and therefore I'm automatically feeling so much better. Whereas when you have a property dispute, you have a commercial dispute, you have a spouse dispute, you go and explain to your lawyer and the lawyer says, I'm so sorry, but with all this 1 hour of storytelling that you have done, I can only find out that 4 relevant law points that I can put in my petition for you. And so at the end of the day, you read the petition and you say, is this what I'm supposed to go to court with? There are so many times that parties win a matter and they say, oh, is that all that I get at the end of this 8 years, 10 years of my legal battle? Yes, ma'am, this is all that you get at the end of 10. But I'm not satisfied. I'm not happy. Whereas in mediation, you mention the matter directly on the face of the opposite party, being facilitated by the mediator. You see the body language. You see why that person in a commercial matter did not pay your fees. Why was he raising all frivolous complaints against you, etc., etc. So direct communication between the opposing parties, that's what we did. Continuing relationship. The moment you file a suit against another person, you think you're ever going to even look at each other? You're going to try and avoid even if you see each other a mile away. Whereas in mediation, the thing is, you face each other, there is a face-off. You understand things, you realize that parties did not want to do what they did. And probably if we were in their shoes, we would have ended up doing the same thing. And therefore, you ultimately reach a place where you want to forgive and forget. And you may even want to be friends. That's stretching a little too far, but it has happened. It is a process which is voluntary. Yes, completely voluntary. You come and go as you like. You may just say that, today we are not interested in continuing anymore with this particular problem because we have to do a reality check. We'll come back. You can always say that we want a different mediator. You can also say that, I might only want to do one big family arrangement. The other residuary factors we do not want to touch. Fair enough. That is also can be done. Therefore, completely voluntary as to your presence, as to the scope of the conflicts, as to the settlement of the conflicts, everything voluntary. Definitely, privacy and confidentiality. Privacy, you don't have to shout out your matter in a court of law, in a judicial process. You don't have to shout out the matter before an arbitrator where every side gets 10 juniors. It is 20 people hear the matter. The juniors go outside and talk about the matter. It could even become a judicial precedent and people read about your matter. So therefore, no privacy to that extent, no confidentiality too. Whereas in the case of in mediation, the most important thing is privacy. Apart from the mediator and the parties before the mediator and the lawyers, if at all, nobody else is allowed to remain present. So complete privacy. What about confidentiality? The mediator in the opening statement itself makes it very, very clear that parties, whatever is stated, whatever is said between the parties will remain within the four walls. It won't go outside the four walls, and therefore complete confidentiality. The matter fails, nothing will be carried out of that room to a court of law, to another person's ears, etc. Many places also sign a confidentiality agreement to that extent. Remedies available are much broader. Yes, you don't have to stick to the four corners of the law. You have remedies which you can come up with. You have there is a fight between brothers, houses in the context of, say, a distribution between them. They can sell the house. They can have a house exchange. They can sell it and share the sale proceeds. They can share it as their third house. Anything which they can come up with, they are allowed, which won't be allowed in a court of law or in an arbitration, because you have to stick within the four corners of the procedure code. Mediation promotes finality. How? The matter never goes to appeal. Who will go in appeal? You have brought in the scope of your conflicts, your dispute. You have suggested the remedies. You have reached a mediated settlement agreement. No one has forced you to sign it. At the last minute also, you should not put ink to paper. So it remains between you, you're happy with it, and therefore no appeal. So it reaches finality. Mediation mediation always takes into account long-term and underlying interest. How? We'll do it a little later. And mutually beneficial agreement, we have already done. Now, to quickly understand, therefore, what is the process of mediation? Now, whenever parties come before the mediator explains to them what you call as the process of mediation. And to my mind, I think these 7 points will aptly cover up the process of mediation. And how will they cover it up in stages? We'll do it in the next slide. So first we have what you call as an introduction, understanding the problem. In an introduction, as the word goes, the mediator introduces herself, himself, and asks parties to get introduced. Understanding the problem. How does the mediator do that? Deeper understanding of their interests and their needs, defining the problem, creating options to those problems, evaluating each of the options suggested, and then either it goes into a settlement or no settlement. Now, whether there is a settlement or no settlement, the whole process instills in parties a sense of satisfaction, because here is one process where you have your opponent, your enemy sitting right across you, and you are exchanging words of mouth, body language, expressions under the facilitation of a mediator. At the end of the day, you realize that, the enemy is not an enemy, because I seem to understand where his shoe bites him, like my shoe bites me in a different place. And you seem to understand, and wisdom dawns upon you. Now, what are the stages of mediation in which we can instill those processes? 1, introduction, opening statement, and ground rules. Now, that will fulfill the first process of mediation. Now, like we said, let's look at introduction. Now, what is the objective of an introduction? 1, it establishes neutrality. In what way? The mediator convinces the parties, like say, hello, I'm Dr. Gitanjali Prabhu. I've been appointed as a mediator by the Main Mediation Center, High Court, Mumbai, and welcome. And I congratulate you for having chosen mediation as a form of resolution. Let me tell you clearly that I am a complete neutral, in the sense that first, I do not know any one of you. Therefore, there is no question of bias. I do not know the parties. I do not know the lawyers. Second, I do not know the subject matter of your dispute. Third, I'm not at all interested in the outcome of whatever the dispute that is going to, we are going to reach a resolution on. You people are going to discuss, raise options. I'm not aware of it. And it makes no difference to me. And that is neutrality. Create an awareness and understanding of the process. Yes. Now you have to tell them that I'm sure you people are eager to know what the process of mediation is. When a litigant goes to the advocate for the first time, the advocate, they first ask the advocate, what will happen? Now, what will I file? Which court will I file? After that, what will happen? How long will I have to wait? How will I know who the judge is? What if I fail at the first level? What happens thereafter? Same way, they need to be aware. They are curious about the mediation process. And that is when the mediator, in brief, explains to them that right now, what we are having is our opening statement, is a mediator's opening statement, after which you will be doing your opening statement and telling me your stories in your own words. Your lawyers will add to it if they have anything to add as to legal points. And thereafter, once we have narrated stories, we'll decide what are the issues really at hand. How many of the issues you want to decide with me today? How many of the issues you want to decide at what point of time? We'll take on with that. And then we will generate options to find out that how we are going to resolve these issues that you people have raised. Now, the other objective of introduction is that he develops a rapport with the parties. He asks them, how far have you come from? I hope the journey was okay. I hope the train didn't take much time. Would you like a glass of water? So he makes them comfortable and he develops a rapport with the parties by talking small, insignificant things to make them feel more comfortable. The other basic reason for introduction is you want to gain the confidence and trust of the parties. How does the mediator do that? Now, when the mediator says that I'm so and so, the mediator also adds that, I have done n number of your matters. Don't worry, you're in safe hand. So, like I always say, and this is my favorite sentence, that your introduction should be crisp and brief, not, and it should not tantamount to be bragging about yourself. I did this, I have done many matters, so you don't have to worry. I have no, just keep it simple, formal, and it should invoke in them a trust, a confidence in you that yes, we are in safe hand, like a driver of a vehicle who says, yes, ma'am, I have driven many vehicles. The Ola Uber app also tells you that you have a five-star driver who's done so many trips. So okay, it doesn't give you a big narration about how many awards he has earned or what qualification he has. No, nothing. And you know that you are in safe hands. Something similar to that. Establish an environment that is conducive to constructive negotiation. Now, how do you do that? You bring them in a room, you put them in a sitting arrangement in such a way that they are facing you, but right now they are not facing each other. So all four are facing you, the two parties and the two lawyers. So they are acutely aware of each other's body language, but they are already looking at the mediator and explaining their point of view and listening to the mediator with rapt attention. So the mediator is giving them an environment that is very, very safe. They may say whatever they like. Nothing is going to be held against them. They may make mistakes. They may learn from their mistake. They may vent a little bit and say a little more than what they initially intended to. Everything is fine because the mediator is there to cover up for them. Motivate the parties for an amicable settlement of the dispute. So you have to motivate parties to tell them that, look, you have got this golden chance. Please don't lose it. Make full use of it. You are going to go to court. That is there. Nobody is taking away that chance from you. But if you give your best shot over here, you have only to gain. Nothing to lose. Nothing. The only thing that you're going to lose is that litigation in court, that waiting period, that loss of time, that loss of money, that burden on the courts. That's all that you're going to lose. What will you gain in contrast? You will gain a complete resolution of your conflict. You will go home and begin life anew, thinking and putting aside this big Damocles sword which was hanging on your head till now, that now I have put the matter to rest. Now this is the end of the matter. Now let me live my life like a normal person. That is what you're going to not only gain for yourself, but gift to the other side. And that's a very, very big deal. Ask anyone who has a matter pending in court. Establish control over the process. Now remember one thing. A mediator controls nothing, my dear friends, nothing except the process. The mediator only controls the mediation process. The moment the process is derailed, the parties will lose confidence and the whole process will fail. So the only thing that the mediator needs to be aware of all the time is to keep a control of the process. And how he does it, we will soon come to. So while continuing with introduction, mediator introduces himself by giving name, areas of specialization. Second, oh, sorry, I think there's a repetition. I'm so sorry. Thereafter, the mediator requests each party to introduce himself. He may elicit some more information. Then mediator then will ask the counsel to introduce themselves. And most important, the last point, please note, we have to find out as mediators as to whether the parties sitting before you if he represent any corporate or he represent any firm or individual or proprietor or body of person, he has the necessary authority to appear, not a resolution by the board to simply appear, but whether he has got the authority to resolve that amount of dispute. So there comes a stage when you have a matter of 40 lakhs or 50 lakhs, and the man says at the end of the negotiation that, ma'am, I'm so sorry, I do not have authority to, resolve something over 50 lakhs. That my senior will do. The whole process gets derailed because he has gone through the whole negotiation and now he says that I never had the authority to participate. So be careful. So therefore, what is the opening statement? One, you give them the concept and the process of mediation. You explain to them the stages of mediation. You give them what the role of a mediator is, a facilitative role. You give them what the role of the advocates is, that the advocates will narrate the legal aspects of the case. You give them what role they will play. They will play the central role. They will say their stories. They will raise options. They will come to a resolution by their own. And now the most important part is you lay certain ground rules. In your opening statement, what are the things that are mandatorily required as a mediator for you to offer? And when there is a feedback received from the parties, it is mandatory to record some of these things. One is that you have to inform the parties that mediation is voluntary. You have to tell them that it is self-determinative, that they are the ones who are going to decide. You are just going to facilitate their conversation. You will never foist a settlement on them. You have to tell them it is mandatory that it is confidential, and nothing stated there or nothing which passes there will then go to other person ears, nor will be used in any proceeding for or against them. Also, it's a time-bound process. So depending from the referral court, where the matter has come from, you have to mention that now, look, we have only 3 months within which we have to try this. Otherwise, I'm sorry, I have to refer this matter back to the referral court. You have to tell them that this process is informal and flexible, that you may bring in any conflict. So there is a matter pending in court. You have only 2 disputes there. If there are any surrounding disputes between the same set of parties, you may bring it here and we can always see whether that can be resolved. Direct and active participation of the parties, that it is party central. Then I told you about neutrality and impartiality, that finality, there will be no appeal. It is a consent term. It's binding between you. Possibility of settling related disputes. This is somewhere close to, we can say, oh, I forgot to say good faith participation. Now, what is good faith participation? You have to tell the parties that you must participate honestly. You can, just because you have to tell your stories, please do not say things that are not real, that are not the truth, because on what you say, the other side is going to narrate or lever his case on the basis of what you say and promise. So there should be good faith participation. Need and relevance of separate session. Yes, you have to tell them that right now, what is going on between us, me as a mediator, you as parties and your lawyers, we are right now in a joint session. But there could come a stage when I want, or it is necessary that you may want to tell me something confidential, which you are not very sure of sharing at that moment with everybody. And you may request for a separate session, also called as a caucus. So you may ask me, ma'am, can we have few minutes with you? So when you're telling that in a opening statement, you should also tell parties, don't worry, the moment I have a caucus with one party, I will definitely have a caucus with you too. So there is no need to worry on that aspect or create bias. Now, what are the ground rules that we were talking about? So we finished introduction, we understood opening statement, and with ground rules, the mediator will complete his opening statement and will then share the baton to the parties to begin their story. Now, what are the ground rules and why do we need ground rules? We need ground rules to maintain some decorum for the mediator to control the process. So the mediator will say that ordinarily, I would like that you don't talk amongst yourself. Please speak to and address the mediator. Secondly, most important, while one person is talking, please refrain from interfering, make notes, as you wouldn't like to be thwarted, to be, shouted at, to be intruded. So also, every one of us would like to complete what they have to say. So please make a record of what you would like to say. And once you have said your story, you can completely reply or respond to what the other side has stated. Language should be polite and respectful. Mutual respect should be maintained, not only for yourselves, for the parties, but for the process. Mobile phones may be kept on silent or switched off so that we make complete use of this 1 hour that is given to us, and after which you can always go back to your mobiles. And second, lastly, adequate opportunity will be given to all parties to have their say. These are the ground rules. The moment the ground rules are done, the mediator immediately calls upon the parties to begin telling each of their story. Now, about joint session. The joint session is where the mediator is there with all the parties. Now, what is the objective of a joint session? One, gather information. How? The moment the mediator finish, the mediator will request parties to tell their stories. Remember, no pleadings are filed. Mediator is not even aware of basically what their dispute is, except that two paragraphs, a scanned copy is sent to the mediator's email. So the mediator may barely know that, an amount of about, say, 20 lakh, 30 lakh, 80 lakh, whatever amount is due and pending from each of them. Beyond that, for what, why, etc. Generally, the mediator is never aware and learns everything from the parties themselves. So while gathering information, the mediator is also providing the opportunity for parties to hear. Now, whilst the one party is speaking, the other party is listening. The other party is noticing what aspect I'm agreeing to, what aspect I'm not agreeing to. And when each of them talks, each one understands their perspective. Because otherwise, in arbitration, in litigation, it is the advocates talking. Here, the feelings speak. Because if they are saying that they cannot make a payment, they cannot make a payment because of n number of reasons. It is not because I don't want to make a payment, or it is because the quality of work which was offered by the side was not good, because of which there was a loss of reputation. They served untold hardships. The place had to be opened, now got delayed, and the place opened, say, after 3 months. All this thing is told by the part. Now, what is the disadvantage? I mean, what is the thing that you have to keep note of? When a lawyer speaks only what is going to be down within the four corners of the law book. But when parties speak, they speak more out of feelings, emotions, and when they initially begin, it can be 70 to 80 to 90% of emotion with hardly 10% which will make sense. What does the mediator do at that time? Because now the other side also has to respond. And in all this gibberish, the other side will wonder what is to be responded to in this story. Therefore, we have something called as, the parties also need to know that, they have been understood, they have been heard. How does the mediator do that? The mediator, the moment the parties pause, the mediator butts in and says, okay, so what I hear from you is that, you provided excellent service as an architect to the other side. And the work went on for 3 years and you were hardly paid anything. You also went to different suppliers and you got, material of highest quality. When actually the work began, it was of so much, this quality. And now all need to be paid and they're all gunning after you for the material, for the payment. And the other side is not making the payments to you and therefore you're suffering. And I also hear that you have taken a loan to pay them off and you're paying heavy amount of interest on that. Yes, yes, I hear you. So when you are paraphrasing their problems, when you are not only showing that you understand them, but you're also showing that they are heard and they feel a sense of relief. Also, indirectly, you're telling the other side that these are the points on which you would like him to give you an answer. That why haven't you made the payment for so long time? And is what he's saying everything? Is it correct? Is it true that he gave you excellent quality service? That the suppliers were even then you did not pay. Is it true? That is what goes on between the parties. So understand obstacles, and so whilst they are talking, the other side is responding in a joint session. You continue to have exchanges. Mediator is all the while looking at them, observing them, learning what are their strengths, what are their weaknesses, are they violent by nature, are they subdued, are they saying things which they really want to say, or they have it. And the mediator then should invite parties to narrate their case, explain their perspectives, vent emotions, express feelings without interruption or challenge. So the parties will keep on in the flow. They know that nobody is going to interrupt me. I can say all that I like. First, generally, between the parties, you should ask who would like to go first. So the applicant always says, ma'am, since it is my case, I would like to say it first. And it works that way because as the respondent, they can respond to what he is saying. After which you have counsels giving their say. Mediator encourages and promote. Now, what does the mediator do basically in a joint session? In a joint session, the mediator sees to it that there should be enough communication, that parties should keep on talking relentlessly about their stories, perspective, because this is the time the mediator is gathering information. The mediator is finding out what is ailing them, why the conflict has reached a crescendo that they have decided to put all their time, money into a court matter. What is it that they really want? And therefore, that can only happen when the mediator keeps on shuffling them and keeps on getting information. Now, as I told you, at times there could be a way that you want to have one-on-one with the parties because of what reason. Now, when you want, after gathering information, you want to reach at a deeper level of information. And therefore, you tend to call for a separate session, also called as caucus. What do? When you want to understand the dispute at a deeper level, you also want to provide a forum to the parties to vent their emotion, because when they are together, they don't want to vent it out in front of the other side. They have self-respect. They may become violent. They may become they may start on a story and they may land into some other place which is meaningless. And when you call for a caucus, you ask the party, what is it that you really want? Why are you being so violent? Do you think violence is going to help us reach a resolution? Do you think because you act violent, the other party is going to respect you? What is going to happen? And therefore, when you rebuke them in a joint session, they may just get up and walk away, and the mediation process will fall through. But when you will immediately call for a caucus and then ask the party gently as to what happened, why is it that you are behaving in this fashion? Or why is it that you're just going on in circles and not going beyond that? You're not creating any options. Then it is the caucus or the separate session where the mediator can do all this. The mediator also finds out what is the underlying need. So what is the thing is that there are two things in mediation, a position and interest. Position is what I want. I want the Taj Mahal, bhai. I want the Taj Mahal. But what about need? When you say, my position is that ego, my need is my necessity. So in a caucus, when you sit with parties, you come across them and you learn as humans that they may come in with an ego that I want the Taj Mahal, but actually the need is that they may just be wanting to, it is absolutely necessary that they have this, the money which is outstanding, due and payable to them because of the heavy loan which is hanging on their heads. So therefore, you understand the underlying interest, you help parties to realistically understand the case. Now, how do you do that? If the party says, okay, ma'am, I'm ready to pay off whatever outstanding is due. Now you take him in a caucus and you explain to him that when you were in a joint session, you agreed to pay this amount within a period of, say, you said 4 months. How are you going to pay this amount? Are you going to take a loan? Do you have money sitting in your bank? Does your company agree for this? So you give him a reality check. Even a reality check is given in a caucus. Shift parties to a solution finding mood. So when they are together in a joint session, they're busy arguing, showing off, having ego hassles and ego issues. But when you take them in a caucus, they will be in a solution finding mood. So what is the procedure? You reaffirm confidentiality. You tell them that, look, now we are in a caucus or a separate session. Whatever you will tell me will remain with me. I'm not going to share it with anyone unless and until you tell me to, and to the extent that you want me to. Nothing more than that I'm going to share with anybody. And you begin by reaffirming confidentiality. Then you gather information, find out what are the topics on which they want to talk, but they right now don't want to talk. And at the end of the caucus, you tell them, okay, you told me this, you told me this, you told me this. Now, how much part of it you want me to share? Because now I'm going to have a caucus with other side. So will you let me know what helps? And that way, you convince the parties to give out information and how they want to go about disclosing it to the other side. Reality testing, we just did reality testing. I told you, suppose they have come out with the option that, yes, I'm going to pay him, ma'am, within a period of 6 months. Then how will you make the payment? Will you do an RTGS? Will you, do it in installments? The first installment will be a larger one, or the last installment, or will they be uniform installments, etc., etc. I'm going to share this PPT with all of you, and therefore, if you have any more questions and etc., then you can always reach out and ask. Then in reality testing, we have some techniques. So first of all, the techniques of reality testing is asking effective questions. Now, among asking effective questions, what is the effective way? We have what you call as open-ended questions. Okay, we have closed questions. We have questions that bring out facts. We have questions that bring out positions and interests. Now, what is the meaning of that? Open-ended questions are questions which will get, when you want to gather more and more information. Like for example, you want to say, okay, so you are interested in buying that house. How will you go about doing that? Okay. And then I see. And if that doesn't work in this way, so you keep on prodding that person because you want to have more and more information. When you want to pin that person to a particular point of a yes, no, then you ask a close-ended question by saying, so will you do it or not? That will be a close-ended question. For example, like I have said over here, on which date was the contract signed? Etc., etc. So you are asking a close-ended question where the answer is very specific. Now, questions that bring out the facts. Facts? Okay, tell me what happened. Not what you think, what happened. Position. So therefore now, what are the damages that you're claiming? Now, this is your position of ego. Whereas interest is, I have got hurt, please pay my hospital bills. Can be the need. That is the way, one of the way is asking effective question. Second, discussing the strength and weaknesses of the respective cases of the parties. Now remember one thing, you can never do this in a joint session. Because in a joint session, when you put in the weaknesses and strengths of the parties, the other parties will try to take advantage. Therefore, when you want to discuss the strength and weakness of the parties, it is always better to do it in a separate session or a caucus. Also consider the consequences of failure. When you are sitting in a caucus, you can tell them, look, sir, if we don't work out this matter, you're going back to court. And if you go back to court, you are seeing another 10 years before you see the resolution of the case. Are you willing to do that? Or do you want to sacrifice a little and meet somewhere midway so that we can put an end to this thing? When I began in the beginning, I told you all that mediation is a negotiation process. Now, when in negotiation, they have these three terminologies, maybe one fourth is also there. BATNA. BATNA means best alternative to a negotiated settlement. So if you don't do a negotiated settlement, what is your alternative? Your alternative is to go to court. So is your BATNA today of settlement much better than you're going to court? That is what you have to tell him. What is your worst alternative? If you're not getting a good deal here, would you rather than go to court? What is the worst that you are looking at? And most likely, when both the parties have given their options, and when you keep on talking with them, you reach a midpoint and you understand what is the most likely alternative that they are going to have. And then you have also what is called as ZOPA. ZOPA is zone of possible settlement. And that is how, when parties keep on telling what their problems are, what their requirements are, interests and position keep on shifting and changing, and you have made them aware of the alternatives and you have given them a reality check, you realize that the zone of possible agreement will be within these four corners. Now, negotiation by itself is a very, very big topic in mediation. Then we have one more technique, which is called as brainstorming. We all know what brainstorming is. So brainstorming means that when options are raised, you take each option, depending on parties may feel that, if this option gets decided, if this issue gets decided, the other issues can be resolved on the basis of this decision. Therefore, you take that particular issue and we try to then rack our brains to think about a possible outcome. So you keep on asking open-ended question, close-ended question to make. Like, for example, if he's saying, ma'am, I'm thinking about this house. So now you want to prod him. But as a mediator, you're not allowed to make suggestions. So how do you do it? You say, so what do you think? Do you think it's a good idea for you to, keep this house, or you want to exchange another house along with this house? Or you think it is better to just sell this house and keep the sale proceeds? So what do you do? Indirectly, you are narrating that what could be the thinking factor. So you're making him put on the thinking cap there and then for him to arrive at a particular conclusion. You're helping him, you're prodding him without seeming to do so. He should feel that I am doing the thinking for myself now. It's not you who are foisting your ideas on me. So brainstorming has two factors. You need to have a lateral thinking and you need to have a linear thinking. You can read it up, and it's mostly to do with a lot of tools. Now, there is also one thing which you need to know, and that is succession. Now, what are succession? Sometimes you need to take the help and support of the lawyers to help their parties to understand. So once you have the advocates with you, you can make the advocates, make their parties realize to see sense in settling the matter. Therefore, you could have a succession with only one of the parties, one of the advocates, and get them to come on your side by finding out what are the things which are standing in their way from settling this matter. And that is again something which you need to tell in your opening statement, that apart from caucus, I might have subsessions with the parties. This we have done, that you could put forth an exchange offer along with the other reality tests that you have. Then we come to the last stage, and that is the stage of closing. Now, what has happened before this? You have done you have done joint sessions, you have done separate session, you have then again come to joint session, again done separate session. You keep on doing this, carrying the offers, carrying the settlements back to the parties in a joint session, finding finding out what their demands are, to what extent they are agreeing, carrying it back to the caucus, negotiating with the parties there, again bringing them together in the joint session. Till now, you get each of the issues settled either fully, partially, or thrown out. Now, once you have reached the settlement, then you put pen to paper and ink out each of those decisions that you have reached. So what happened? In the closing, the mediator orally confirms the terms of settlement. It is reduced in writing. Agreement is read by all, narrated to all. Mediator reaffirms whether yes, you have understood. Is this what you have agreed? Do you want me to add, modify, delete any portion of it? Or should we just, go ahead and sign it? A mediator also signs the agreement because it shows that the mediator was present and mediator facilitated that settlement between the parties. But the mediator cannot be called as a witness in any court of law for that agreement. And as far as possible, the mediator will then say that now you can take this settlement and in a court annex matter, you can produce the settlement before a court of law and the court will pass an order in terms of that settlement. If it is a pre-institution, the mediator will attach that to the report and submit it to the District Legal Services Authority, who will then put it online and declare the matter as settled between the parties. Then mediator thanks the parties for their cooperation and tells them that I hope you have learned a lot in mediation and I have also learned a lot from you. The mediated settlement agreement is a very, very important document. So therefore, what should it contain? It should contain the terms as agreed between the parties. It should be in very, very simple language because it is arrived at between the parties and not going to be part of any court of law. It should be something which should not use any ambiguous words. It should be something which the parties want to be noted and understood between them, and there should be it should be complete in its recitals. So if the parties do not pay or complete the payment, then what will happen? How much amount of interest will be payable? How will the amount be paid, etc., etc. All this should be narrated in great detail. When there is no settlement, then the mediator merely makes a report to the referral court by saying, no matter not settled. So there is a judgment which covers this, which says that you don't have to give any reason. You have to merely mention that the matter was not settled. I had told you that, basically it is a negotiating process. Therefore, if you ask me in brief, ma'am, you narrated the whole process. So how do we go about, explaining the whole mediation process in brief? I would put it in this. So there are three elements to the whole process. I would call it connecting, crafting, and choosing. In connecting, you have a relationship between the parties and you communicate with them. In crafting, you find out the interests of the parties, not their position. Interest is need. Why they want it. Why, not what. Why. Options for settlement. So many options are created. Options, either you sell the house, either you exchange the house, or you pay portion of the sale proceeds and keep the house for half the house for yourself, or you use it as a vacation home. So these are the options that you have created. And then you have legitimacy of the interest of. It is easy to mention an option, but it is very difficult to find out whether it is legitimate, whether there is a reality behind it. whether it can reach its conclusion. So many mediations fail, dehodes the fact that parties reach a settlement, but they don't have the wherewithal to satisfy the claims that they had made in a mediation meeting or in a settlement. And last is the choosing elements, which is commitment. The commitment of the parties to make it happen, what they have mentioned in their various meetings before the mediator, and the alternatives available to them. Please understand, there's always a mistake between option and alternative. Alternative is, if not mediation, then what? You go back to a court of law. But what are options? For the problem, how many options you have to solve that particular option. So I call these the 3 C's, how the mediator goes about bringing the mediation process into magic. Communication tools. What are the tools which are there with a mediator? 1, active listening. What is the meaning of active listening? A mediator listens active. I think I have a slide for active listening here. Resist the common urge to think about what we are going to say next while our counterpart. So when the parties are speaking to you, you listen, not only to listen, but to understand. What are they trying to tell you? Are they hurt? Are they cheating? Are they cunning? Do they have a, ulterior motive? Or they are innocent? Or they are very keen to settle? What is it? From where is it coming? That is what a mediator needs to find out. So active listening is listen for the purpose of understanding, not for the purpose of responding or replying. So listen carefully to the arguments, and how do you make the parties feel heard? By paraphrasing it for them, by putting it in your own language. So whenever they speak something violently or negatively, you put it and say that, yes, I can feel that hurt you're feeling because you're not being cared for by your spouse, or you have not been paid your fees. I can feel the hurt. So that is the way you just in brief summarize their all the venting that they have done before you. And also you acknowledge difficult feelings, like I feel you're frustrated with the fact that you have not been paid for the services which were rendered 2.5 years ago, and your matter has already been pending for 1 year. So I know how difficult it must have been for you. So you once the person feels that they are not only heard, there is somebody who's found the time to hear them, to understand them, and to make them feel that I have been heard and understood, is a very, very big message of mediation. Not only are we likely to acquire valuable information, but the other party may mimic your exemplary listening skill. Means it has to be infectious. The moment you behave in a particular way, you will automatically find that after a period of time, parties will be mirroring you. They will also be treating you the way you're treating them. If you are gentle, if you are willing to give them that time and patience, they will also try, though it is very much difficult, because they are the ones in the suffering position. So in communication tools, we did what we called as active listening. And in active listening, the second one is, as we did, when we acknowledge what has been said and felt by using paraphrasing and summarizing. We summarize what they are trying to tell us. Most important, the magic sentence: listen to understand, speak to be understood. No use of speaking in a very, very high profile English, or a jargon which they are not going to understand. Be simple, come down to their level or go up to their level. Be earnest, be keen that they understand what you want to say. And when you say, they should be keen to listen to you, because it is coming from a place which is meant for their good and not for your feeling of power, that I'm going to be this all source that is going to put you to end of your misery kind of a situation. Speak only for a purpose. Otherwise, keep your ears open and keep on listening. So if you feel that your speaking is going to make a difference, speak. Otherwise, just stay quiet and let them do the talking, because they're venting, is more important than your speaking. Okay, thank you. And I've completed a task within the time. So now time for your questions. Rakesh, if you're there, help me with the link.
Ma'am, good afternoon. This side Naveen Kumar from ICSI.
Hello.
Yes, we have some questions. I'm sharing it with you.
Yeah, is it in the chat?
Yes. I'm giving it.
Okay, wonderful. Yeah.
Only
Yes,
5
wonderful.
questions are there.
Yes, wonderful. The first one is excellent question. And I applaud whoever raised this question. I wanted to do this, but please forgive me. The lecture is only for 1 hour. Imagine we do 40 hours of mediation training. In 1 hour, I have tried to encompass all this. Definitely, we can have an online mode. In fact, listen to this. Whenever a matter, so I am a hands-on counsel in court. I'm a hands-on arbitrator appointed by court and by institution, and I'm also doing mediation regularly every single day. Before the lecture, I just finished one mediation. Now, the simple fact is why and how. Simple. They send you an email that you have been appointed a mediator. Here's the scanned copy of the letter appointing you. A brief thing is given about the matter and the names and contact number. Immediately, you send out an email to the parties and say that I have been appointed as a mediator. I'm going to fix my first preliminary meeting on this day at this time. Kindly acknowledge this mail. You may be present with your lawyer, but parties have to be mandatorily present. Also, let me know if the time is convenient. Otherwise, we'll have to mutually decide on a beneficial time. Since it is the first meeting and you are one of the parties is out of town, then let us do on Zoom meetings, after which we can decide at what stage we would like to have a physical meeting. So definitely online mode is something which we are not only doing arbitration. I do most of my arbitration on an online mode till it comes to cross-examination and evidence, where we do a few physical meetings and wrap it up fast. After that, it is so. Otherwise, it would be impossible. So online is definitely a blessing. So my answer to that question is yes, authorized representative can appear, an advocate can also appear, but because it is a party-centric process, parties must compulsorily appear. Now, what can happen is when you are hearing their stories, advocates are very busy. You can, by consent, excuse the presence of lawyers till you don't reach a little more stage where you know the matter is getting settled. So over a period of time, the advocates may appear and keep their, audio, video switched off and be there in the background. But actually, the mediators are having a one-to-one between the parties and, themselves. So then the advocates may themselves say, ma'am, since this is, just nothing to do with the law, could we be excused till the next time when, you really need us to forge some legal compliances? And you definitely happily agree. Okay. So yes, definitely. And in fact, let me tell you, it is very, very important that we have advocates to come with parties, because firstly, it is the advocate who will identify the parties for you. It is the advocate who will be the one who will verify the stories that they are telling you. It will be the advocate who will see through the mediated settlement agreement, and thereafter, whatever happens, the follow-up is all done by the advocates. So they have to be there with you, definitely. Question number 2, how the mediation can be done where one party is based out of India? Excellent question. I wanted to do this also with you all. You all know that we have what you call as a Singapore Convention. Just like in arbitration, we have the New York Convention. Here we have a Singapore Convention, which deals with, if you give me a chance next time, I'll happily do international commercial mediation with you all. So the convention says what will be the seat of mediation, how will they go about the, again, online, parties decide between themselves. The happy part of mediation is everything is party-centric. You do everything online and it gets decided where they want to meet and sign the agreement. Then, of course, because it is by consent term, you don't need to really have an approach to courts like in arbitration. Is mediation binding and can it be contested? Okay, now these are two different questions, sir. Whoever has asked it. Binding, definitely. Number one, Section 89 of the Civil Procedure already tells you that if you have a binding settlement, then that settlement, look, I told you that there are three types of mediation. One is the court annexed. The moment you reach a mediated settlement agreement, you carry it to court. The matter gets called out. The advocate will inform, ma'am or lordship, we have reached this settlement before ma'am, and I'm presenting the mediated settlement agreement. Court will take the mediated settlement agreement, narrate on so and so date, so and so was appointed as a mediators. Parties appeared before the mediator. Parties have reached a consensual minutes of the order or mediated settlement agreement between the parties. I'm taking this on record. Order in terms of the mediated settlement agreement. Binding. What happens in case of a pre-institution matter? In pre-institution matter gets settled. Immediately, the district legal services has to be handed over 3 sets of copies signed by us all. That immediately becomes an order of the court and binding. So binding. But you are asking me second question. Can it be contested? It does not require a contest. Why will you contest something which you have signed by yourself with your own consent? So no contest required unless, of course, you're right. In case you find out that, false and fabricated statements were made before the mediator, and then therefore it needs to be set aside. Then it can be done in any court of law, and all the remedies available in case of fraud and forgery will be available to you. Next, who can become a mediator? Anyone can become a mediator. Anyone. You don't have to be a lawyer to be a mediator. In fact, you won't believe when you have a corporate sector set up, every department in the corporate sector can have a trained mediator at their level, so that every nipping conflict which arises can be nipped in the bud to the mediator of that department. So you can have an in-house mediator, you can have a lawyer who's practicing, you can have a chartered secretary as a practicing mediator. When there is a dispute between anybody, as a chartered secretary, you can be appointed as a mediator. Anyone can be a mediator. How can I divert my career from an in-house counsel and CS to being a mediator? I have 18 years of work experience as an in-house. Excellent. So I have actually 25, no, I have 30 years in the profession, and I'm still a practicing counsel. So it's a role play. When I go to court, I do adversarial matters. When I sit in mediation, I become a mediator. When I'm in an arbitration matter, I become an arbitrator. But now what did I do for that? For the longest of time, I denied that there is something called mediation. And I thought that, every matter that could be must be before the court of law, because that is the only thing which seems to be binding and will put a period and a full stop to the dispute. But no, I realized when I took my IICA training, so you take any robust training, even whilst you're an in-house counsel, continue, because that is giving you a fat salary. Continue being an in-house counsel, but simultaneously do a robust mediation course. There is now, which I have done so late, because we didn't have MCPC training in Maharashtra for the longest of time. But now we have a MCPC, that is a Mediation Conciliation Project Committee of the Supreme Court is having trainings. You could go to the Bar Council. Bar Council will help you, and it is a 5-day residential course which you can do, and you can then come on to the main mediation center panel or the district legal services panel in the city court at Mazgaon, Dindoshi, and they will continue to send you online work. For that, you don't have to stop being an in-house counsel or a CS, and you have 18 years to your command. So why should you? So I continue to be a practicing counsel. I take up lectures. It all depends on, the happiness of being a professional. Otherwise, I would have taken up a job long ago. So if I'm in a mood today, I can work for 24 hours. If I'm not in a mood, I can just laze for 24 hours. That's the happiness of being a professional, and I don't think you should stop being one. Okay. What is the difference between an arbitration and mediation? Okay. If you look at my slide, you will know. Number one, in arbitration, the arbitrator gets appointed under the Arbitration Act, but there is one important thing. There should be an arbitration agreement already standing between the parties, and therefore they can already even refer present and future disputes, but they can always reach an arbitration agreement. But agreement is necessary. That right now we are undergoing this conflict. We want to put it to arbitration, and therefore we are signing this arbitration agreement. The moment the agreement is there, you need an arbitrator. How do you get an arbitrator? Either you consent to an arbitrator, it could be an individual or an institution which will refer an arbitrator, or you go to court under Section 11 of the Arbitration and Conciliation Act of 1996, get yourself an arbitrator foisted by the court. Generally, it is the Chief Justice Court or any judge delegated by him, or you name a particular person by consent and have him sitting as an arbitrator for you. Then you also know that you may have an individual arbitrator or one by each party, and the third will be an umpire, and therefore that is your tribunal. In mediation, you get a mediator depending upon the type of mediation. Court annex mediation, I told you, the mediator gets appointed by the court directly or through the main mediation center. Pre-institution, it gets appointed by the District Legal Services Authority by sending you an email. For that, you have to make a proper application to the District Legal Service Authority, convincing him that you have the required qualification to be a mediator. After verifying and checking, they put you on the roll and they on the panel, and you start getting matters. So the difference between arbitration and mediation is this, that in arbitration, you will get an award. In mediation, you will get a mediated settlement agreement. In arbitration, once you get an award, then that award can be challenged by whichever party is against by going to the court of law under Section 34, 37, under different clauses, but very, very minimalistic ground, there is a ground of challenge. In mediation, because it is a consent mediated settlement agreement, therefore the question of going to a court of law doesn't arise. What other mediation? In arbitration, you have pleadings, papers filed. It is as per law, a court of law. An arbitrator cannot of his own imagine, say, oh, I'm feeling very sorry for you, therefore I'm going to pass an order. No, dear, you can't do that. You have to stick within the four corners of the law, because tomorrow a single judge will be sitting on your order, on your award, and striking it down if he finds it ex facie to be against the law. Simple. In a mediation, they can come to any conclusion. You don't have to seek and reek in law into it. As long as they are the correct parties, they have done something which is correct under the law of the land, ethical, not against public policy, etc., etc., and they are of sound mind, and under contract, they can contract that. They can do anything and decide. They can sell their house, buy their house. Nobody is going to question them. They can foist anything upon themselves. What else I can see as a distinction? Yeah, in arbitration and mediation, the thing is, in case of arbitration, you have fees which you have to pay to an arbitrator. In case of mediation, the mediation fees is generally paid in advance to the District Legal Services Authority or to the main mediation center, and you get your fees directly from there. What more? I think I have more or less covered everything, from appointment, from the proceeding before them, from the award, and their binding nature.
Yes, ma'am, you have explained all the provisions very well. So now, no more questions at all.
All right.
I, on behalf of the institute, as well as on behalf of the participants, wish to express sincere thanks to you for all this explaining very well, ma'am. Thank you very much, ma'am. Thank you. Thank you very
much. My pleasure. Thank you. Thank you. So with your permission, I'm going to leave the meeting. Thank you so much.
Yes, ma'am. Yes, please.
Thank you.
Thank you, ma'am.